anybody, but rather the very best and recognized voices in this area, and that is indeed what we have this morning with Jeremy Waldron, and this evening with Jeremy Waldron and Jonathan Turley. I want to talk to you just a little bit about format. The first, we're going to begin with short presentations by both Jeremy and Jonathan with very, very brief introductions by myself. After that, if you're wondering why these chairs are here, we're going to sit in the chairs and engage in a conversation, which I'll begin with some questions, but we're hoping you all will have questions. I'm sorry, did I say you all? Y'all will have some questions to present as well. And I think you all got cards when you came in, and we have more cards somewhere. So I hope you will have questions on this important, and in some ways, especially for us here at Rice, very timely topic. I want to add a special thanks, in addition to the extraordinary generosity and vision of Milton and Laurie Boniuk. I want to add a special thanks to Charlie Landgraf. Charlie's one of those folks who really exemplifies, I think, what's called servant leadership. It's not enough that he's my boss and a trustee. He actually goes out and does some of the things that somehow I can't figure out how to get done, and this is actually one of those things. Charlie, I just want to thank you for the fact that you are just always, always there for us. So we're going to begin by hearing from Jeremy Waldron, who teaches legal and political philosophy at NYU School of Law, where he's a university professor. Immediately prior to that, he held the Chichely Professor of Social and Political Theory at Oxford University, which I think is the most prestigious position you can have as a legal or political philosopher. Although before that, he was on the Columbia Law School faculty, where we met, and Jeremy joined the faculty shortly after I became dean and left shortly after I came to Rice University. I'm going to take that somehow as a compliment, but this is a very special occasion for me to have this reunion with Jeremy, who is a remarkable thinker and scholar, and I would just add, personally, human being. His books include Dignity, Rank, and Rights, Party Laws Common to All Mankind, Foreign Law and American Courts, The Harm of Hate Speech, which you can, relevant to this, which you can order on Amazon or get in your local bookstore, Law and Disagreement, The Dignity of Legislation. I'll just stop there. He's originally from New Zealand, in case he sounds a little funny to you. Studied at Oxford University for his doctorate after earning his undergraduate and master's degrees at the University of Otago. And as I said, has since taught in a variety of the world's best institutions: University of Edinburgh, University of California, Berkeley, Princeton, mentioned Columbia Law School, a fellow of the American Academy of Arts and Sciences, has basically invited to give every prestigious lecture there is on the planet when it comes to law and legal philosophy at Harvard, Berkeley, Oxford, Edinburgh. Please join me in welcoming Jeremy Waldron.
Thank you, David. And I too wanted to thank Milton and Laurie Boniuk for this invitation here tonight. Charlie Landgraf, who made the phone call and brought me here. And it's a pleasure of my life to be with these people in this room to talk about this timely issue about hate speech and hate speech legislation. As David said to you, I'm a New Zealander. And so I was more than usually upset by the news that came in on March the 15th, that a young man, an Australian white supremacist, had slaughtered 50 people at mosques in Christchurch, which is a city in the South Island, injuring another 30. Terrible, terrible toll. A white supremacist who had been motivated by and contributed to a great deal of hate speech of an anti-Islamic character. Many people watching the news that came from Christchurch were impressed by the work that the New Zealand Prime Minister, Jacinda Ardern, did in response to the events, not least the work that she did in thinking about reforms which that relatively peaceful country now had to contemplate. Number one, to its gun laws, which had remained reasonably permissive and had enabled this troubled young man to obtain semi-automatic weapons. But also, as soon as that legislative agenda is finished, they do want to have a look at their hate speech laws. And I thought that would be a good point of departure this evening for our reflections on hate speech laws. Can I read you the existing provision as it is? And then we'll talk about how it's shaped, how it's formatted, and most important for you, how it's justified. So this is the New Zealand Human Rights Act, section 61, which says, "It shall be unlawful for any person to broadcast or use in any public place words which are threatening, abusive, or insulting, being words likely to excite hostility against or bring into contempt any group of persons in or who may be coming to New Zealand." Notice that sort of reference to New Zealand as a country of immigration. Words likely to excite hostility against or bring into contempt any group of persons in or who may be coming to New Zealand on the ground of the colour, race, ethnic or national origins of that group of persons. So it's a race-related hate speech statute, and it's made an offence, not a grave offence, but an offence punishable by a substantial fine. And I imagine that the work that has to be done subsequent to the March 15 massacre is at the very least to modify the definition so that it begins to encompass religious hatred as well as racial hatred. People who might use words intended to excite hostility against or bring into contempt any group of persons defined by their faith, as well as any group of persons defined by their race or ethnic origin. Notice how this is structured. It does not attempt to penalise speech because that speech is fueled by hatred or motivated by hatred or driven by hatred or is an expression of hatred. It's dealing with speech that causes hatred, that excites hostility. So the speech is the cause, the hostility is the effect, as opposed to when we talk about hate crimes, if somebody kills somebody and that killing is motivated by a racial or religious animus or sexual animus, we say that was a hate crime, and there we are talking about the intention which caused the killing. But here for hate speech legislation, and this is true more or less of every other country that has hate speech legislation, which is every other advanced democracy in the world, the laws are structured so that what they condemn and penalise is language that is designed or calculated or likely to stir up hatred against a group. So hatred is the effect, not the cause, in the scheme of this legislation. And it's done, as all legislation is undertaken, to prevent certain harms. It's thought as a matter of public policy that it is, number one, tremendously important to avoid a situation where intercommunal hostility grows up in a community. You see this around the world. You see it in Nigeria, you see it a bit in India. We had experience of it in Northern Ireland, where communities defined by ethnicity or religion are at each other's throats, not just a few organised groups, but serious intercommunal hostility, which is one of the worst things that can befall a society. And countries that are about to become countries of immigration, say Britain in the 1960s, had to contemplate the possibility that there might be anti-immigrant forces that would try to stir up hatred in this existing society against new groups, and it was thought that this was not something that legislators could neglect in their public policy making. So the first dimension of the harm of hate speech, that's the name of my book, is the worry that it might contribute to the stirring up of intercommunal hostility, at the very least, that it would make it much more difficult for a society to adjust, make the adjustments and the modifications in ways of life that would enable people to live tolerantly, side by side, with others whose faith or appearance or customs were unfamiliar to them. And the second harm of hate speech was thinking really about the defamatory aspect of hate speech. A number of European countries, when they talk about hate speech, the German Penal Code talks about a person who attacks the human dignity of others by insulting, maliciously degrading, or defaming parts of the population. Not just defaming them in the way that a specific libel or a specific piece of slander might defame a person, but defaming people by virtue of their membership in a particular group, by saying, I don't know, all Muslims are terrorists, or by talking about African Americans as being all violent or something like that, taking a group characteristic, associating it with some slur, some defamation, which would affect people's ability to operate in society as ordinary members in good standing of the matter. And there was a time around the 1950s in this country where we took very seriously the possibility of group defamation. Jonathan will be aware of the case of Boniuk against Illinois, which was the last time a hate speech statute was upheld by the Supreme Court of the United States, which dealt with the question of group defamation. At Columbia, David, before my time, certainly before yours, there was an attempt by one of the clinics associated with the law school to draft a model group defamation statute. And defamation was often seen as a concern in race relations and in relations between groups. You heard of the Anti-Defamation League, concerned with combating anti-Semitism and so on. So that's a second theme of undermining the basic standing of ordinary members of a group by associating their very being in the society with as it were, a slanderous slur, an unfavorable characteristic. So we want to protect the society against intercommunal hostility. We want to protect particular people against the impact of this hostility being stirred up against them in particular. And thirdly, and this is the thing that we have to think about in relation to the events in New Zealand, we have to worry about hate speech inflaming and motivating, stirring up troubled young men with access to firearms who may then be tempted to act out in these murderous ways. At least those three dimensions of hate speech are the sorts of things that people have had in mind when they felt it necessary maybe to compromise the principle of free speech with statutes like this. And I don't want to go on too much about the detail of it, but the theory of this legislation is that these evils are in a way like environmental harms. These evils are like environmental harms. They create an atmosphere in which it's more likely that there'll be violent episodes, an atmosphere in which it's more difficult for people to live their ordinary lives, bring up their children and conduct their businesses, an atmosphere where intercommunal hostility is more likely, not because anybody's particular act of hate speech immediately causes such hostility, but it injects an element of slow-acting poison into the fabric of ordinary life, rather analogous to the way in which racism or sexism in a workplace or university might create a hostile environment. So we think about that in environmental terms. Not necessarily as the imminent result of any particular action, but rather in the way that the unmitigated emissions from my car, my automobile, might mingle with the unmitigated emissions from 100,000 other automobiles and create a pollution hazard that wouldn't exist just from one car alone. So it's that sort of logic of social environment that I think is a matter of concern. These laws exist in most advanced democracies. Controversies about these laws exist in most advanced democracies. It's not just the United States where there's a strong current of free speech opposition. There is a debate, and it's healthy that we're talking tonight, but there would be similar debates in New Zealand and Great Britain and Canada and Australia. These laws have to be drafted with the utmost care to try to do the least damage or derogate to the least extent from the hate speech principle, so that they try to, for example, if they are concerned with protecting Muslims from having hatred stirred up against Muslims, from having defamation of Muslims as they try to lead their ordinary lives, they need to somehow separate that concern from concerns about people's views about Islam or their views about the Prophet. And so you find, and this is something New Zealand will have to think about as it modifies its laws, in the United Kingdom, where there is a law prohibiting the stirring up of religious hatred, they have added a free speech provision which says, nothing in this part shall be read in a way which prohibits or restricts discussion, criticism, or even expressions of antipathy, dislike, ridicule, insult, or abuse of particular religions or the beliefs and practices of their adherents or of any other belief system. You try to separate an attack on the religion, which is not prohibited, from an attack on the persons, which is prohibited, or attack on the dignity or the standing or the reputation of the persons, which is prohibited. It's not protective of religion as such, it's protective of the persons and the communities who practice. It's a fine line, and it's a matter of legislative judgment exactly how to word that. And I say all this, and this is the last thing that I want to say in what's already surpassed, I think, my 10 minutes. I believe very firmly, I don't believe that every country needs or should have hate speech laws. There's a genuine controversy and there's a genuine debate about values here. But I believe it ought to be a matter of legislative judgment. It's a matter of the judgment being made by those who have responsibility for the well-being of the community. And they have to decide what to do about the spectre of intercommunal hostility, or about the defamation of particular people, or about the stirring up of whatever enraged this young man to go and kill 50 Muslims in Christchurch. They have to worry about the effectiveness of this, and judging the effectiveness of something either ex post, as we lawyers say, from looking back. It's just as hard as it is trying to judge it ex ante, but the difficulty of it doesn't mean that we can be excused from making or hazarding such judgments. We've got to think about possible effectiveness. The lawmakers in Britain had to think about what would happen in a country newly becoming a country of immigration, people coming from the Caribbean and from East Asia and South Asia and East Africa. If intercommunal hostility were to continue unabated, with gasoline being poured on it from time to time by irresponsible speakers and writers, they need to consider how things would go if that were not governed by law and how things would go if it were governed by law. Difficult question of effectiveness. And I'm sure Jonathan and I will have to talk about that issue of effectiveness. But let me say just one last thing. These statutes are not just instrumental to the prevention of the harms that I've mentioned, although that's the most important feature of them. They are also, in a way, expressive of the society's determination to associate itself with religious toleration and with the reduction of hostility and the protection of individual dignity. Sometimes we lawyers don't say enough about the expressive function of law, but I think it's very important here. It's a way in which a community can say, in the strongest possible terms, here we stand and we will not put up with this, which I think is what the New Zealand Parliament is going to have to do when it introduces opposition to religious hate speech into its already existing provisions relating to racial hate speech. So just to start the ball rolling, I want to say in the words of the consigliere to the Godfather, do me a favor and take this into consideration when you think about these matters. Thank you very much indeed.
I actually want to correct one thing about my introduction of Jeremy, because I may have left a misimpression. In New Zealand, he did earn a degree in law and was admitted to the bar and to practice before the Supreme Court. And I do want to say he's one of those philosophers who takes very seriously at the same time the law and has a great familiarity with legal decisions. That's not true of all the philosophers or even legal philosophers. So now with a slightly different point of view on these topics, it's my pleasure to introduce Jonathan Turley. Now, for many of you, Jonathan may need no introduction, and you may have, you walked in, have thought, that face looks just a little bit familiar to me, and you may have seen him on any number of news shows, particularly as a legal analyst for CBS News and the BBC, and particularly in these times when there are a lot of legal issues floating around. He is one of the most visible legal commentators in the United States today. He is a prolific writer. Like Jeremy, he has the courage to take positions that may not always be popular with everyone, including positions that are not always popular with people who may otherwise identify with him from a political point of view. Jonathan received his bachelor's degree from the University of Chicago in 1983 and his JD degree from Northwestern in 1987. He's currently holds the Shapiro Chair for Public Interest Law at the George Washington University Law School, where he teaches torts, which is very close to my heart as the subject I taught, criminal procedure, and constitutional law. He was the youngest person to ever receive an academic chair in the school's history. He runs the Project for Older Prisoners, the Environmental Law Clinic, Environmental Legislation Project. He has been ranked as one of the most cited public intellectuals in the United States, both generally and in terms of being a law professor. Please join me in welcoming Jonathan Turley.
Thank you very much. Let me begin by thanking the Institute and Rice University and President Leebron, and also my esteemed colleague, Jeremy Waldron, who I appreciate is allowing me to speak today. Because after I read all of the language of the codes that he was advocating, I was pretty sure that I was barred from speaking entirely. But let's give this a try, and we'll take it as far as we can, and Jeremy will let us know. As a threshold matter, I'm required to say, and talking about a chilling effect, everything I say here has nothing to do with CBS, BBC, or the papers I write for, which is a great relief to them. So let's talk about this. It may surprise you that Jeremy and I agree on three salient points. First, hate speech is grotesque, and hate speech is harmful. And third, Jeremy's winning this debate. It's true. He's winning this debate all around the world. Free speech is on the decline. The West has fallen out of love with free speech. It used to be the thing that defined us. It used to be the touchstone of what was considered freedom. Now it's more often talked about as a scourge, the thing that divides us, the thing that has to be controlled. Jeremy speaks of it as an environmental harm, like we're experiencing the global warming of speech. He talks about it as a slow-acting poison. Perhaps it is. In some ways, it's a poison like the polio vaccine. You know, a small number of people that receive the polio vaccine have a paralytic reaction that's quite serious. If you focus on that reaction, one couldn't imagine why you'd give anyone the vaccine. When Jeremy says worst things that befall society that come from speech, He's referring to that paralytic reaction of a certain percentage of people who cannot tolerate free speech. What's missing is that there's one worse thing, and it's called tyranny. That's what free speech gave us. It inoculated us from tyranny. It gave us the freedoms we have today, which are meaningless if we begin to compromise on free speech. Free speech doesn't have an easy trade-off. It needs a bright line to live, or it creates a chilling effect. And the chilling effect of these laws is perfectly glacial. If you listen to Jeremy's codes, you can see that chilling effect easily. I'll quote back some of the things that Jeremy quoted with great support just a few minutes ago. That we're going to be able to stop speech that, quote, attacks human dignity, that's insulting, that's degrading, that's defaming. Who will make that decision? What is the most telling thing about these codes is that what constitutes improper speech is usually defined on how the speech is received rather than intended. These codes talk about the intent behind speech. But when Jeremy says that we're looking at the effects of speech, we're really not looking at the effects of speech. People are being arrested right after they speak. We're presuming the effects by how people might receive them. Now, it's very hard to make that argument, which is why I'm losing this debate. I'm a dinosaur. I'm one of those Voltaire dinosaurs. I really believe in free speech, and I have no question where we will be if we start to compromise on it. But free speech is an abstraction. It's hard to get people to support an abstraction. Jeremy began with the quintessential way of arguing for speech codes. He talked about the massacre on March 15th. How could anyone not be motivated to act when you see that type of grotesque crime? That's real. I'm just selling you something abstract. Hell, when I go to college universities, I ask students how much they'd sell me their free speech for. I usually suggest $250,000. I used to say $2 million, but it was too big for people to imagine. $250,000 is about what would pay for their tuition, down payment on a car. When I started saying $250,000, hands started to go up. Because you can see these students really asking themselves, when's the last time I used free speech? That's $250K. I could put that in terms. And so the cause and effect becomes very, very easy. As Jeremy said, that we have to deal with this person, this murderer in New Zealand, to try to figure out what made him so hateful, what made him, in Jeremy's words, enraged. I know what made him enraged. Hate. It wasn't caused by speech. We've had hateful people throughout our time as humanity. Hate's a terrible thing because it exists even in non-oxygen space. There's some people naturally inclined to it. So let me give you some specifics, the most specifics that I can offer. And that is, under the codes that Jeremy just quoted you, what does constitute prosecutable criminal speech? In France, any insults directed to a person or group based on race, religion, gender, sexual orientation, or handicap, an insult is a criminal offense. Brigitte Bardot was prosecuted repeatedly because she wrote the minister, at that time Sarkozy, who was Minister of the Interior, because she felt that homosexuals and Muslims were ruining France. He turned over the letter to prosecutors, and she was successfully prosecuted. Designer John Galliano was prosecuted for saying something anti-Semitic in a restaurant. A mayor was successfully prosecuted because he complained about how many immigrant children were flooding into his school system. In England, a threat, an insult, anything likely to cause harassment or alarm. Likely to cause alarm. When I read that, I stopped. I was like, for the love of Mike, likely to cause alarm? And then I got to the next word, likely to cause distress. Distress? I'm a Chicago Cubs fan. I've lived in distress my entire life. In England, Barry Threw was arrested because he wore a T-shirt that said, "Kill cops for fun." Home Secretary Amber Judd was accused of a hate crime because she was complaining about foreign workers coming into the country. Neil Phelps in England was prosecuted for making a Nelson Mandela joke. A Baptist preacher was arrested because he said homosexuality is a sin. A teenager was arrested for holding up a sign outside the Scientology headquarters saying Scientology is a cult. Now, when Jeremy talks about Germany, I thought that was particularly interesting. Germany, in fact, is one of the leaders in this, but I do want to say something about a philosophical difference between Europe and the United States, but I'll get to in a second. But Germany certainly had cause to try to restrict speech. After World War II, they barred even the symbol of the Nazis, the Nazi salute. They barred Nazi speeches, Nazi terms. How's that worked out? Is that why there's no neo-Nazis left in Germany? Why there's no white supremacy left in Germany? All those thousands of people marching in Germany? That's because we were able to change the environment that Jeremy was talking about? It had the opposite effect, and it always does. Forcing neo-Nazis underground does nothing but make them a victim. And they thrive on it. You ban the swastika, they change the symbol slightly. You ban the salute, they change the salute slightly. Speech like water has a fine way of coming out and undermining any foundation. Germany hasn't made any progress, any more than we have. But that's the weird thing about this. You would think that this would be my day. Jeremy was getting up here to sell something that I was pretty sure you couldn't sell. It was like selling White Sox hats on the north side. It couldn't be done. He was going to go in front of a group of free people and convince you to give up part of your freedom. How am I losing to this guy? Because I am. So is all the free speech advocates. Because we've fallen out of love with it. So in Germany, they have great triumphs. They arrested a guy 2 years ago because he had a Mein Kampf speech on his phone instead of a ringer. Now that strikes me as pretty weird. But what a great day for tolerance. We got the guy with the ringer for Mein Kampf. They arrested a bunch of people who were selling Mein Kampf wine, which I must imagine would be particularly dreadful. The best thing you could do is have people drink Mein Kampf wine as their punishment. A pet owner was prosecuted because as a joke, he trained a dog to give a Nazi salute. Not because he's a Nazi, he thought it was a joke. By the way, comedians are being arrested left and right under these codes. Every one of these countries have arrested comedians for making jokes. So is Canada. Canada had a stand-up comedian who got into trash talk with a table of lesbian listeners. And they trash talked, and he was prosecuted and convicted because it was viewed as using their sexuality for a public comment. Now, recently, the European Union looked at a case out of Austria that started in 2009. An Austrian teacher had a class where she compared Muhammad's marriage to a 6-year-old girl to pedophilia. She was convicted of a hate crime. The European Court of Human Rights upheld the conviction. and said that packing incriminating statements into wrapping of an otherwise acceptable expression of opinion and claim is not going to convince anyone. There went free speech. Now, here's the difference, and I think this is where Jeremy and I have a fundamental difference in how we view free speech, and it is a deep one. Because when I go to Europe, I often have a certain problem of translation, particularly in England. The United States came from a different premise when it considered free speech. When France, really the cradle of many of our democratic traditions, first articulated a free speech protection, it was in Article 11 of the Declaration of Rights of Man and of the Citizen in the French Revolution. It was, by the way, that was partially drafted by Lafayette with input from Thomas Jefferson, although it's not clear that they had any role in Article 11. But Article 11 speaks to defending the free rights of humanity as one of those basic rights, but then adds that the speaker shall be responsible for abuses of this freedom as shall be defined by law. England also has had the same type of European tradition. They've never recognized freedom of speech as a core right. It's done largely by statute, precisely what Jeremy's talking about, that this should be handled by statute. It's a very English view. That, the English have enjoyed a benign government. They trust their government. That's a joke in the United States, right? What's the most scary thing ever said? Trust me, I'm the government. In Europe, they actually believe that. So in the United States, we took a different approach. We said the following thing: Congress shall make no law abridging the freedom of speech. See, where Article 11 could have put a period after freedom of speech, we did. No law abridging freedom of speech. And when Hugo Black had a case where people were arguing that we had to limit speech, Hugo Black said, I take no law abridging speech to mean no law abridging speech. It may be crude, maybe it's juvenile, maybe it's naive. It is different. That's why we're standing here alone. Because Jeremy is right. When he says every other country has done it, all the cool kids are doing it. We've never done it. And God help us, we never will. So, I'll end with this. One of the most disgraceful moments in history, at least modern history, was the massacre of the Charlie Hebdo editors and journalists by another enraged person. By the way, as Jeremy looks for what's enraging him, he got enraged in a country that didn't have free speech the way we define it. But he still was enraged enough to kill a bunch of journalists and editors. And there was this great parade of world leaders through Paris to support free speech. And in the front was a rogues gallery of the countries and leaders that had been cracking down on freedom of the press and free speech for decades, including Turkish President Erdogan, who, by the way, got Merkel to promise to prosecute a comedian because he told a joke about him. The one person that wasn't there, that was not there, was the only surviving senior editor. Someone found him, and he said, no, I didn't go because I wanted to throw up. He said all those people, including the French president, his government had spent the last 10 years trying to put us in jail. All those people that died at that office spent 10 years trying to stay out of jail. And so they all gathered at this plaza where that famous statue is to liberty, equality, and fraternity. And they celebrated free speech as they define it. But they've redefined it. It's no longer liberty, equality, and fraternity. It's just equality and fraternity. Free speech is being sacrificed on the altar of fraternity and equality. And it is a sad, sad trade to make, because you may end up with none of those things. Because there is a poison in a system, and it's not free speech, as Jeremy suggests. It's tyranny. I suggest we focus on that scourge and take its vaccine. Thank you.
Misrepresentation. We have a whole host of areas where, in fact, we have reached a compromise on free speech. In cases like defamation, we have very high standards for public figures, lower standards for ordinary folks, but we've reached a compromise. And so why is it in this particular area, and if we sort of credit Jeremy and to even a small degree, and we say the harms here can be large, and maybe that's your answer, but why not in this area? What's kind of different about this context that we're willing to make these compromises in all these other areas where in some ways the countervailing interests may be less in terms of some arguments? What's the difference that you see there?
Well, the one qualification I would make, maybe I should move this away. I guess am I making a buzzing sound for you? It's because what I say is so divine. Is this okay?
Yeah.
The one qualification I would make is that all those are examples largely of civil liability, that we're talking about what can be a criminal act largely in these codes. But more importantly, some of them describe acts. I'm sorry, this is really buzzing, isn't it?
I don't know if there's a way to turn this down. Do we have anybody managing it?
What if I put it over here? What's my iron constitution? Should I just stand there, maybe so that it doesn't drive people crazy?
Or turn it off and see if people can hear you. Talk loud.
Can you hear me without it?
Yeah.
Okay, let's do it that way. Most of the things that were...
I just want to be clear, this was not an attempt to suppress any speech here.
A clumsy attempt, but an attempt nonetheless.
Most of those things are acts. We have no problem with criminalizing acts. So fraud is an act. You have taken an act to defraud someone, which often results in a pecuniary loss. Defamation is a civil fine. No one is suggesting that you should be free of any accountability for statements that may harm someone in a civil way. The question is whether society can stop you from speaking, to create a speech code. And don't make any mistake about it. What Jeremy was reading is a speech code, what you are allowed to say. And it is often a criminal code. So we have no problem with criminalizing acts. But I don't know of any compromise of free speech in the United States. There are some criminal free speech provisions. For example, you can have imminent criminal conduct under the Brandenburg standard, something, quite frankly, I've been a critic of my whole career, and I have a case going to the Supreme Court which I hope can result in a rewriting of Brandenburg. But the court did recognize that if you have speech that is asking for imminent violent acts to occur, that can be punished. That is as far as we've gone, generally. The rest of the stuff in terms of discrimination laws, etc., those deal with actions taken that create a hostile workplace, etc., that can be regulated. Well, we're talking about criminal speech codes.
Do you want to say anything about that or take my next question?
No, let me just talk a little bit about that. I think one of the things we have to realize is that although Jonathan is absolutely right about the criminal code in this country, in many people's workplaces, in educational institutes, in the army, if people engage in racial, anti-Semitic, religious vituperation, they will not just be the subject of private lawsuits. Their employer will dismiss them. People use racial epithets on the television. They're gone. I mean, you know this. It's one of the ways in which we mitigate the effects of having this open regime that you can say anything you like. Yes, you can, but only in certain situations. I think it's very, very important to acknowledge that we recognize the importance of speech codes in employment areas. Goodness me, if somebody came into my law school classroom and started shouting anti-Semitic slogans, not only would I arrange to have them quickly removed from the room, but I would arrange to talk to the dean about whether they were fit and proper person for the practice of law. And I don't think, I mean, just because we have a mission to perform in the classroom, and it requires not just a degree of intellectual discipline, but it also requires a degree of mutual respect among those who are studying, learning, and teaching the law. So I do think it's important when we try to consider what there might be to be said in favor of these speech codes. And just to be clear, Jonathan, I wasn't urging anybody in the United States to give up their vaunted freedoms and immediately institute. I just wanted to explain what might be behind this otherwise mysterious viral pattern of legislation that so worries you. But I do think that, in fact, we maintain a kind of a two-level system here. And I believe in many ways it's quite important. It's not just civil and criminal liability. It's also we define certain workplaces and places of learning where people are to be protected from the worst manifestations of hate.
Can I add one thing to that? Because I think Jeremy and I agree on certainly I have no disagreement with what you've said. But in the United States, we also do have this dichotomy. The First Amendment protects only against government action, the big brother model. We don't have protections against little brothers. We don't have protection against private employers. That's not necessarily a bad thing, but it actually, for some of us worried about free speech in the United States, the little brother problem is actually getting more and more serious in terms of its chilling effect on speech. But the whole premise was, we're worried about government-mandated speech codes. We're not protecting people from how their fellow citizens deal with them, how the repercussions of their words. In fact, I've always wondered why Germany went down the path it did. The best thing you can do is to get extremists to speak publicly, so we know who they are. And I do believe in that old-fashioned idea that the best way to deal with bad speech is better speech. But the last thing you want to do is to force these people underground.
I want to come back. Did you want to?
Just responding to that, I mean, it's a perfectly reasonable concern to try to make sure that the hatred and the purveying of hate is at least done in the sunshine, where the sun can bleach it out and so on. Bear in mind, though, what some of the haters say. You remember there was a little town in Illinois called Skokie, and there was to be a Nazi march through a Jewish district in this city with people holding crudely lettered signs saying Hitler should have finished the job and other racist and anti-Semitic filth. And one of the things that Frank Colin, who was the leader of the little band of Nazis engaged in the Skokie march, said, he said, here's what we want to do. We want to reach the good people. We want to get the fierce anti-Semites who live among the Jews to come out of the woodwork and stand up for themselves. There was a suggestion that we want to create anti-Semitism now, not just as a furtive thing held shamefully, but as a public good whereby people can call out to each other like wolves in the night and bolster and reinforce each other's concerns. Now, I take that seriously. That was the man speaking for himself.
I do too, but so you wouldn't have allowed the Skokie March to occur. Is that what you're saying?
That's right.
Yeah, see that's an amazing thing to me, because
well, there are many
but allowing the Skokie March to occur was a celebration of free speech, to show these people that we're not going to change our views because of them. And when we have these extremists show up, for every 20 of these broken toys that show up and spew hate, there's often 2,000 people that show up and say, we don't stand with you. But at the same time, those people recognize they have a right to speak, but they're there to show that we don't accept what they have to say. And then that demonstration of hate becomes a demonstration of our common values, not their values. But we don't let them change us. Right. That's the reason I think Skokie was important.
It's a perfectly reasonable point of view, except we shouldn't sell short the great debate and the difficult controversy that took place even among the members of the ACLU, the American Civil Liberties Union, at the time of Skokie. And I wouldn't, for the world, disparage or belittle those people who were genuinely exercised by this as an open question.
So I want to come back, Jeremy, to a point that Jonathan made, but I want to start with, as one always should, with a quote by Yogi Berra, which is, in theory, practice and the theory are the same, but in practice they ain't.
Right.
And so, you know, I think one of the fundamental difficulties here, and I think it's the one that really underlies what Jonathan's concern is kind of who decides, right? If something is hate speech, who decides? How do we know that it's going to be the same under the present government of the United States as it would have been 4 years ago under the government of the United States? And are we exposing ourselves to an exercise of power where the ability to regulate divisive speech, which is an argument that, you know, one has sometimes heard in the most autocratic, tyrannical societies, you know, there's division. You look at the suppression of minorities in any number of countries around the world, and sometimes the argument made is, well, we're just making sure there's no division in our society. So how do you think about the sort of who gets to decide, and why should we have this level of confidence in that practicality of something that sounds pretty good in theory?
Sure. So we have to think about the details of prosecutorial discretion in relation to these statutes. Now, for the New Zealand statute that I mentioned and for the British statute, there's a specific provision that these decisions must be made by the Attorney General. That's the Attorney General of the whole country. Now, to understand this, you need to understand that the Attorney General is an office which is partly political and partly and emphatically non-political, and there are certain duties that the Attorney General has to perform that are understood not to be party political. And I see Jonathan smiling, and we can disparage that.
I was actually smirking. That's
There will be no smirking.
But we do have a tradition in those countries of the Attorney General making certain decisions that are to be made effectively, not as a party political despot, but as a responsible person in charge of the public good. It struck me as very interesting that the counterexamples from England that Jonathan mentioned, you know, the guy standing up saying Scientology is a cult, were from parts of the Public Order Act that prohibited not racial or religious hate speech, but prohibited threatening, abusive, and insulting behavior causing alarm and distress. You remember those phrases that you quoted? No reference to hate speech at all there. It's Section 5 of the Public Order Act. By the time you get to the racial and religious provisions, you're into Section 29 and so on of the Public Order Act. And the remarkable thing is that it's the latter provisions, the religious hate speech provision, the racial hate speech provision, that are subject to this Attorney General filter, which has been put there as part of the tactics of protecting the principle of free speech. Let me just finish. I'm sorry, Jonathan. The statutory provisions at the beginning of the Act, which are not hate speech provisions at all, but just banning various forms of disorderly speech, are not subject to that filter, which is why you're getting the idiotic cases that Jonathan mentioned.
Well, I think the answer, Jeremy, is revealing, because it does show the type of tradition of having faith in the benign government.
Sure.
You know, that prosecutorial discretion is, you know, we have to rely on people making good judgments. That's something that may be a foreign concept in the United States, but certainly the framers did not accept that. You know, Madison was famous for his statement that if all men were angels, no government would be necessary. He was not willing to accept promises of good behavior by governments. He wanted a clarity, and that clarity was found in a special way ultimately in the Bill of Rights. But to leave it to a politician to make the decision, you are on a fool's errand. I mean, many of these people speaking are vile, grotesque people. We don't need the First Amendment to protect popular speech. That's not why it's there. Popular speech protects itself. We like it. So when people come forward and they say something we all hate, it's hard to say, I want that person to be able to speak. A politician's not going to say that. We have to say it. And so I think that's a big difference between the two approaches.
It's also a difference in, I mean, it's not just a difference of psychology. I think it's a difference of political culture in the way in which certain offices are understood. Goodness me, the British are as skeptical about many of their politicians. Look at what's going on there right now. I mean, complete shambles. But probably they would say that they would far rather trust the Attorney General making a decision under Section 29 of the Public Order Act than trust Mrs. May on Brexit or anywhere else where you have to trust politicians.
So I want to go back to something you emphasized before and kind of make this a question for both of you, but I'll start with you, Jonathan, which goes to kind of consequences. That is, what are we doing in terms of prevention? What are we doing in terms of potentially deterrence? And you in particular emphasized, I would say, an unwillingness to have criminal penalties and distinguished some of the things that I brought up by the fact that they weren't criminal penalties. But there are a whole range of things one might do. One of them, advocated in particular by Milton Boniuk, has been for institutions that host people who sponsor hate speech, for example, not to be eligible to receive charitable contributions that would be tax deductible. So it's not so much a penalty that's imposed in the traditional way of thinking about it, but rather one could argue the withholding of a benefit of a particular kind. So I wanted to get your thoughts, and then I'm going to turn to Jeremy and find out how he thinks about that and other things, but I wanted to get your thoughts on, would that be a more acceptable approach, or limiting it to civil consequences of various kinds? Would that make any difference to you? I think I know the answer to this, but I'm going to ask it anyway.
It's tough because I feel like I finally have a chance to get in the car with the cool kids, and I'm going to say no. No, I don't approve of it, and that does make me more of a purist of free speech. I've never actually disliked being called an absolutist of free speech. I actually do have trouble with the little brother problem, and I'm trying to find a way that we can deal with that. But when it comes to things like tax penalties, I've been a critic of the Bob Jones case. The Bob Jones case was a case where the Supreme Court said that the IRS could withhold non-for-profit status from a university because it was racist. And Bob Jones University is only loosely defined as a university. But it didn't matter to me. What bothered me was that the IRS had taken upon itself to define what speech is against the public interest. It's a very subjective viewpoint. Now, most of us, inside probably rejoiced when Bob Jones was stripped of that tax authority. My initial reaction was a certain degree of satisfaction, but I stopped myself. I have that feeling all the time. It's really a bad problem with being a free speech advocate is you can have no fun at all. And so I don't like that. I don't think the government should be in the position of penalizing people for their speech. I don't think tax status should be based on people's viewpoints at all. I think the non-for-profit tax status means that you're a collection of citizens joining together for some cause or interest. And we don't tax you because we like having a lot of different groups speaking. And I don't care what you say. So in my view, we give tax exemption to every group of citizens or to no group of citizens. I'm okay either way. I just don't want to pick between them.
Yeah. I think I agree with that, and just as I would agree with the suggestion that we shouldn't be picking and choosing among churches for tax-exempt status. One of the reasons why I have a more tolerant view of hate speech statutes than Jonathan does, I think, is that this is and ought to be a matter for the careful work of the criminal law. The careful work of the criminal law in regard to, say, the New Zealand statute I was talking about requires a legal inquiry into the state of mind of the speaker, not in order to determine whether he was hateful in his state of mind, but as to whether he intended to stir up hatred in the community, which I persist is regarding as a social harm, or whether he was recklessly indifferent as to whether hatred would be stirred up by what he said. So that requires an investigation of the intentionality of.
But Jeremy, how do you divine that? If you're saying, well, what is his intention by his speech? Everyone speaking wants to have an influence. I'm trying to influence these people. You're trying to influence these people. But it's sort of a false, test, right? It's like a sort of a facade to say, well, don't worry, we're going to try to figure out your intent. Everyone speaking is trying to influence others. But I'm actually now buzzing on your mic.
You're just.
I obviously incompatible speech.
I'm the only one who has who has a platform here.
Sorry, shutting down everybody here.
Yeah.
But by the way, while we have a pause, I don't know if somebody's collecting the cards or has those. That would be helpful.
Right. But let me just respond to this. I mean, sometimes the matter can be discerned fairly straightforwardly as when somebody says, I'm going to speak now in a way that I hope will stir up hatred against this particular group. They are perfectly candid about it. Sometimes we have to use the old legal aphorism, res ipsa loquitur, the thing speaks for itself. I had a formative experience when I was a young student in Oxford at the end of the 1970s. I used to hang around courtrooms. As David said, I was a lawyer and studying the philosophy of law. And there was a man who was a British neo-Nazi who had been festooning lampposts and walls in a little village near Oxford with depictions of British citizens of African descent as apes, baboons, and gibbons. Hundreds of these posters. And he didn't deny that he'd put them up, and in a way they spoke for themselves as to what his intention was to convince the rest of his fellow citizens, as far as he could, to treat people of African descent in a bestialized way. So he didn't offer any defense, although he pleaded guilty, hoping for jury nullification. The jury convicted him fairly readily. And a crusty old English judge, who you would have thought wouldn't have had much time for this newfangled legislation, said to this racist man, what were you thinking? How do you think we're going to run a society here of many cultures and many races if this sort of nonsense is peddled by you and posted up, smeared up all over the city? And he sent him to jail for 3 months. And in most of the cases where prosecutions are brought, it is patent what the aim and intention is. And very few of them involve people saying, no, it was never my intention to stir up hatred. I was just engaging in this botanical or this zoological experiment or something like that.
But Jeremy, it's funny because that story that you get such relief over fills me with horror. I mean, it's so funny how we look at the same thing because it's not res ipsa loquitur. You just want res loquitur. As long as the thing speaks at all. It's the speaking that's the problem. And, it's not just that we need a bright line for free speech, but when that judge said, how do you think we can have a pluralistic society? It's a strange argument I've heard before. Viewpoint is pluralistic. We have a pluralistic society because we're composed of a great range of different views, and some of them are horrible, some of them are obnoxious, and sometimes the thing that unites us is when we stand against those views. And that's why we are a pluralistic society. Our best moments, like in Skokie, is when we join together because we don't agree with what you're saying. We just agree that you have a right to say it.
Somebody got to bring me the cards? Or?
And don't try. I say, when I listen to Jeremy, I always find myself agreeing with him. And that also fills me with horror. And it's sort of like an old joke. Remember they got a joke about the guy that jumps off the building, and someone says, "How's it going?" As he's going down the floors, and he says, "So far, so good." That's the problem with free speech in Europe. It's so far, so good, but we know exactly where you're going to end up. Right? You're going to hit the ground, and people are going to determine, somebody's going to determine, what is permissible and what is not.
So I'm going to try to, we thought we had fixed it.
Wait, let's try it.
What we need is somebody to turn the volume down on the machine.
Yeah, that was.
Now, what really is going to be about is when I put this on, everything I say will be with Jeremy's viewpoint. I actually think speech codes are a good thing, and that we should give. Oh, no. Sorry.
So I'm going to try to read some of these, and they're shorter than when you actually ask people to stand up, but they're still not short. So, can we agree that even who defines free speech comes with power dynamics? In the Palestinian example, scholars, activists, and the community itself faces barriers related to political power. Can you comment on free speech in this context?
Sure. Can I answer that?
Yes.
Yes. So, Israel is one of the advanced democracies that has reasonably severe hate speech codes, for the obvious reason that amidst all the other perplexities and tragedies of the Israeli-Palestinian situation, there would be genuine havoc if people were stirring up hatred against each other, even to a greater extent than they are already. It's enforced in other ways also, which I think are very, very interesting, that sometimes political parties will be banned, or particular candidates will be banned from standing because of their racist attitudes, either towards some of their fellow citizens, in the case of Israeli Arabs, or in relation to some of their subjects, in relation to Palestinians. But if you go down through the Israeli Penal Code, in the sections of the code that deal with this, they not only prohibit the incitement to racism, they not only prohibit various forms of hate speech, they also protect religious services. They make it an offense to disrupt religious services, for one group to disrupt the services of another. Again, all in the interest, as I think, of basic sanity in a situation where things could ignite and become socially dangerous just like that. And to suggest that Israeli legislators need take or shouldn't have taken any responsibility for such possibilities is, I think, a serious misjudgment.
It's certainly easy to say that if we didn't control speech, we would have chaos and riots.
In Israel.
But in Israel, how's that working out? I mean, Israel is a hotbed of religious strife. Does restricting speech in Israel make a huge difference in that? I would suggest no. I think that is baked into the area. There is a deep-seated religious division in the area that is going to continue. I don't think it's going to be resolved by keeping certain people from speaking. I just don't believe that. But I can't tell you that if we have free speech, that hate will eventually decline, that eventually we'll convince each other. What I can tell you is that once you start restricting speech, it becomes an insatiable appetite. Once you start to deny certain people's speech, you can't figure out why others are allowed to speak. And I don't think Israel's a good example in that respect, because I think that it has an insatiable aspect in Israel.
I'm coming to the conclusion that whether we suppress free speech or not, we ought to suppress bad handwriting. This is for Jonathan. What is your take on Holder versus humanitarian law, which upheld the material support statute? Material support includes free speech deemed to support terrorists. Did the Supreme Court get it wrong by limiting this type of speech?
Well, the extent of Holder's impact on free speech is still being defined. I mentioned a case that I have, the Al-Tamimi case. And that is a case that falls right in the middle of Holder in Brandenburg. In that case, you had a person who was alleged to be the head of the Virginia Jihad, and he was convicted and sentenced to life for statements he made at a dinner with other Muslim men after 9/11. It wasn't taped, but he was charged with encouraging them to go to other countries to fight for Islam. And it goes to this whole question of violent speech and material support. I am horrified by the extent that material support has been expanded. I do national security litigation. I'm a criminal defense attorney. And I've done these terrorism cases. And material support is undefined. It can literally be anything and everything. And that should worry all Americans. That even the smallest act on someone's part can be defined as material support. And that is on purpose. It's to create a chilling effect that is perfectly glacial. After 9/11, Muslim men were being arrested left and right. You just had to walk out on the street and you'd get arrested. It was unbelievable for those of us doing these cases. And so when you tell this community, look, if you do anything that could be viewed as helping someone accused of a connection to a terrorist organization, you can go away for 20 years. Then it shuts them down, and they don't trust anyone, and they don't engage. And for Muslims, by the way, it's a serious problem, because deeply rooted in their religion is this requirement that they have to do good deeds. They have to assist other people, not just Muslims, but non-Muslims alike. And so for the Muslim community, material support has created this unbelievable chilling effect. And they call people like me, and they say, what constitutes material support? If I don't know that this person has this connection, can it still be material support? And I have to tell them honestly, it can be. It can be material support. That's just not right.
So for Jeremy, if hate speech is regulated, the hope seems to effectively regulate hate. But human thought cannot be regulated, especially in the context of the internet age. Don't you worry that this hate will still flourish just without public knowledge and therefore prevent intervention against violence?
No, that's a reasonable question. But remember, we're not trying to regulate the hate of the speaker. We're not trying to regulate the psychology of the speaker. It's not a regulation of hateful expression. What we're trying to regulate is the stirring up of hatred in the audience. And the suggestion is that whether the audience becomes a community of people who are contemptuous of or hostile to another minority is something that other human beings have some control over by their rhetoric. That some forms of rhetoric are irresponsible because they generate hatred in a community directed at others. And so that, I believe, can't be regulated perfectly. No criminal statute regulates perfectly the conduct it prohibits. And often it's very hard to say because we're having to ask a counterfactual question. How would things have gone in Germany? How would things have gone in Britain after the beginning of the immigration movement in the 1960s? How would things have gone in New Zealand as it became a country of immigration if these provisions had not been in place? Asking that now is a very difficult counterfactual question, but it's exactly the question that a responsible legislator has to ask ex ante, up front, from the other point of view. So the aim is not to use these statutes to try to make people less hateful. The aim is to use these statutes to stop irresponsible people from trying to stir up and create hatred where it otherwise wouldn't exist.
So I think there's a rule that if somebody mentions Michel Foucault in a question, you have to read that one. And this
the opposite rule.
is my own be. So Michel Foucault writes about normative politics and how laws influence norms, etc. How do we continue that, and then I can't read this word, in the realm of free speech if we decide to take a step back from enacting speech codes? So I think that's more for Jonathan here.
Well, I think that is, of course, the problem with a free society is that you have to let go. I mean, it's, when Benjamin Franklin gave those chilling words after the Constitutional Convention, when he was asked, Mr. Franklin, what have you wrought? And he said, it's a republic, madam, if you could keep it. And I tell my students all the time, it's the most chilling words any framer ever said.
because it was Benjamin Franklin saying that democracy has the seeds of its own destruction. We give you the power to destroy yourself. And so it's really hard not to use power that you have. You see people spewing hate and causing injury. It takes a lot to say that you will let speech respond to speech. And the answer is, if you want to change the norms in society, you cannot start by silencing some. You won't convince them. Some of them can be convinced. Every once in a while, you'll see people who have lived a life of hate, and something will happen. They'll actually meet an African American or a Jewish person, and some epiphany will happen. But for most of them, we're not going to convince them. But it's not about them. So we have to stop trying to make society into a better image through criminal laws and speech codes, and instead try to raise a generation that respects free speech, and that better speech will prevail. The problem I have is we're raising a generation of censors. In colleges across the country, speech codes are being implemented. Microaggressions are being used to punish people. Microaggressions that I've yet to have anyone define for me what they are. And so I'm not too sure what the next generation is going to understand free speech to be. But for me, I'm not trying to create a normative society like a recipe that I have to put in certain laws, mix them together, and bake. Instead, I'm happy to have a free society, because I'm convinced in the end certain ideas are not going to prevail.
So let me actually take an aspect of that and ask kind of both of you a question. And I won't say I'm surprised by the answer, but it didn't necessarily follow from things you've said before about how we should think about the university and college context, and particularly how we should think about private colleges and universities. So we're not technically constrained by the Constitution. We may or may not be constrained by other federal law and the recent pronouncement by the Trump administration. But you've emphasized the criminal sanctions and the power of the state, and who gets to decide. There are approximately 5,000 institutions of higher education in the United States. And yet, you've taken, I take it now, a very clear position on the applicability of your views against hate speech codes, that they should also apply to the university setting, whether private or public. I take it that's your position.
Yeah, I'm dead set against college speech codes. And actually, my two schools that you mentioned are the diametric opposites. At Northwestern, the president there is a huge advocate of speech codes and microaggressions. At the University of Chicago sent out a letter to new students a couple years ago that said some of you may need to have protected areas for safety, to make you feel safe. And he said, if you do need that, I'm writing you to tell you, please don't come to the University of Chicago, because there are no free speech zones at the University of Chicago. We have free-ranging ideas, and you can respond to them, you can fight them, but you can argue against them, but you cannot silence other people's ideas. At Northwestern, I wrote a column that they had a teacher who held an immigration class and had a wonderful idea. She invited an undocumented person to come in to talk about her life. And then the next class, she had an INS person come in to talk about her career and how they view these issues. So after the first class, when they brought the INS people, students stood and prevented the class from meeting, screaming profanities. And the vice president of Northwestern showed up. And instead of saying, here's a flash for you, Gordon, we're a university. This is a class. You can't stop people from hearing different views. Instead, he said, look, if you promise to be good, why don't you go into the class and see what they say? And so they promised, went in, and then started screaming profanities at the visitor until she had to flee the class. Now, that's not the troublesome part to all of this. The most troublesome is that the students then interviewed with the college paper and gave their own names.
And they were proud that they had stopped this teacher from being able to teach the class. And you would think that Northwestern would say, well, thank you for that. You're expelled because you just stopped an educational class. You're not ready for higher education. And instead, the university took no action at all, and the teacher just canceled the class. That's what happens when universities no longer become a meeting place of ideas, all ideas.
Jeremy?
There's an awful lot to talk about with regard to the university campuses. One thing I think is worth acknowledging, and I hope Jonathan agrees with this, that as well as technical questions about where the constitutional principle of free speech applies and doesn't apply, there's also a general principle lying behind it that applies to all institutions of higher learning. I mean, you and I disagree about what its limits are, but it isn't that we think it's a completely different ballgame at a private university like Rice. The second thing is we need to credit, I think, many of the movements that Jonathan disparages for having made a very considerable contribution to something that may not have been predictable 50 years ago. The elimination of routine racial epithets from public discourse in our universities. The creation of a relatively safe environment for people whose grandparents feared for their lives coming onto university campuses. And I think it's a reasonable question to ask how students who are concerned for each other's sense of welcomeness on a campus should be expected to respond to, I don't know, neo-Nazis marching onto the campus. Are we to say, look, it's part of the higher education that you must sit quietly and listen to what the Nazis have to say, because last week we had an anti-Nazi speaking and it's very important for you to see both points of view, or that we must sit quietly and listen to what the Klan have to say, or the people marching with torches saying Jews will not replace us have to say. I think it's very important to understand that there's a specific mission that the university has, and that sometimes in their juvenile enthusiasm, the students will be patrolling that. Let me add one other thing, and here I really don't know what Jonathan's view is, but let me put cards on the table. I'm a great believer in heckling. I think it's very important if somebody is giving a controversial speech that others have the opportunity to interrupt and shout embarrassing questions. I know that in the countries where I grew up, England, Scotland, New Zealand, it was a routine part of political culture. You'd go to a public meeting where, as it might be, the Prime Minister or some local MP was speaking to the constituents, and people would be shouting comments from the audience, and usually...
Yeah, how could you think such a thing?
I thought such a thing because I've been...
That was my attempted heckle.
I understand. It's
Pretty lame attempt.
a pretty lame attempt.
Yeah.
But what I've noticed in this country is that the moment anybody shouts out any interruption, they're taken out of the room, despite the fact... So I remember sitting in Avery Fisher Hall, which is the orchestra hall in New York. It was a graduation. You must have been there, David, because it was a Columbia Law School graduation. I think you were there. Al Gore, at that stage, Vice President Gore, gave the address. And it was at that time, and he spoke, and somebody stood up from the audience and said, immediately the security people pounced on him and took him away. And all the Columbia free speech professors sat politely in their hands and maybe applauded the person being led away. We do not tolerate in this country that sort of interruption. And we have, and you see what becomes of it. That free speech becomes like special order speeches in the House of Representatives, a deadening succession of speeches without engagement, where not only does everybody sit quietly, but there is no audience to hear. Right? We need to move, and we need to credit the students in our universities, excessive though their reactions sometimes are, of making sure that people are not always necessarily heard on the terms that they'd like to be heard. We want to, I believe, break the connection that's sometimes made between heckling and disorder, which is often, I think, sustained because we now believe in political choreography, and when you give a speech and you've tested everything before focus groups, and you've designed the rises and the falls so as to elicit applause at the right moment, you're infuriated. And your campaign team is infuriated if somebody disrupts the choreography with an interruption. So what I see is happening on the college campuses is that young people are a hard sell. You can't just walk onto their campus and spout racist drivel and expect to be heard. Now, that's not the case that Jonathan talks about, and I acknowledge it, and I think I share his reaction. But the notion that every conservative group is entitled to invite racists onto the campus, who then have to be heard in silence, and that there would be no reaction and a cowed audience has to be forced to listen to them is I think if I were a free speech advocate, I would be ashamed of that.
Of all the things that one should be ashamed of, that would not be it. As you might imagine, disagree. Calling interruptions of speech heckling doesn't do much. It is actually an effort to stop speech. And when you say people have to stand silent, of course you don't. You can stand outside and you can protest and you can hold counter meetings. But to go to a meeting that is not empty, what is happening with these heckling cases is that hundreds of people will come to listen to a viewpoint, and they will be denied that opportunity because a group is drowning out the speaker. I don't think that's a noble act. You're preventing someone from speaking. It's not heckling. You're stopping them from speaking. I had a debate with John Yoo over torture. And John and I fell on different sides of the torture debate when it was happening. And we were having a debate, and of course, periodically someone would stand up and stop the debate by screaming at John Yoo. And when I left, all these protesters came up and seemed to want to be congratulated and said, we were on your side. We wanted to make sure that he couldn't be heard. And I said, I don't know which side you're on, but you're not on mine. I mean, you were preventing someone from speaking because you don't want others to hear his view. Who do you think you convinced? When you were stopping John Yoo from speaking, do you think you convinced people that he was wrong? Or did you seem to suggest that he was the victim? And that he was going to say something that you didn't want them to hear? So no, I think when you stop people from speaking at universities, you're violating a core covenant that we have, that we listen, not without comment, but we let people speak. And then we have questions and answers, and you can make very tough questions. There was a case recently where a professor led students to shut down a conservative speaker. A professor. Where was the nobility in that? Hundreds of people came to hear that person. And a professor said, we're not going to let you speak. And she said, because we don't believe that his type of speech is free speech. Well, that's easy. A lot of people find lots of speech by people they don't agree with not worthy of free speech. So we just heckle each other and we'll listen to nothing. And we'll reduce our communities to either an echo chamber of views that we like or just a scream session, a primordial scream session.
Jonathan, just to push the matter one step further, we should agree that, of course, when the phenomenon of heckling ranges over a spectrum, and at one end of the spectrum you have the shouted question, or the comment, or the contradiction of some factual utterance that has been made. I'm not talking about chanting now, or slow hand clapping, or what's the term you use, profanities. I'm just talking about a shouted question. At the other end of the spectrum, you have the deliberate, concerted attempt to shout everything down. Now, am I right that you're viewing every instance of the first kind as an intimation, or perhaps something that's likely to get out of hand and eventually end up being something of the second kind? Or do you accept that in an active free speech culture, of the sort that you find not in the United States, I'm emphasizing, but you certainly find, say, in the British parliamentary tradition, where people do shout out interruptions, not profanities, not slow hand clapping, but factual interruptions that break up the rhythm of the speaker, that might be a reasonable form of engagement. And if you view things from that end of the spectrum, even though we were talking about items on the spectrum somewhere, that we might want to applaud that mode of engagement, or at least not rule it out of hand, simply because Americans have become used to this other model.
See, I do find it interesting that on every issue of free speech, Jeremy wants to introduce a nuanced scale.
Yeah.
That perhaps some interruptions are different from other interruptions, and every ounce of my body repels against it. And because I am confident that we will never find where on that scale it's permissible. No, I think that when you have an event and bring in some of these conservatives, I don't even know who these people are. There's a guy named Yiannopoulos or something. I've never even heard this guy.
Milo
Yiannopoulos.
Yeah.
And I don't care. I really don't care. All I know is that this is a guy that that conservative students bring to campus and they want to hear. And they have a room and people come. And some people probably don't agree with him. Some people are going to ask really tough questions. But if you're standing up before the question period and trying to shout him down or interrupt him, then no, I think he should be removed, because that's not free speech. You're trying to stop free speech. The rest of us are here because we want to engage him, maybe even argue with him. And you're keeping us from doing it because you don't like us hearing a viewpoint you don't agree with.
That makes me so sad to hear that.
Let me let's start with Jeremy on this question. That, you know, it seems like your idea around hate speech does depend on certain kind of attributes of groups, in effect, some aspect of identity. And we've seen a number of areas where, you know, nationally we've been concerned about discrimination. We've been concerned about what one might call hate speech. And there are a lot of different categories here. And I wonder, are they all the same, or should we think about some of them differently? We have certainly gender, race, religion, sexual orientation, gender identification, ethnicity, national origin. I think I repeated a few of those. But,
sure.
But, you know, I could give you a list, not much longer than that, but it's kind of two questions. That is, should we think about all of those kind of as the same?
Right.
And are there things that are different than those groups that you might also include on that list of things that would be eligible for some hate speech protection?
Right. No, it's a fair question. You see in the New Zealand example I began with, when I was talking at the pulpit there, that they had focused mostly on racial and ethnic characteristics, and now are left in the situation of having to introduce religious characteristics into their drafting. And other countries that have already had religious and racial characteristics have introduced sexual characteristics, leading to some of the cases that have been particularly disturbing from Jonathan's point of view in Canada, for example. And I could imagine somebody suggesting that political characteristics or class characteristics or general philosophical characteristics could be introduced. And I think the case would not as easily be made that there is a particular vulnerability among people to have their lives, their dignity, and their social standing radically diminished by this sort of defamation focusing on this sort of aspect. If somebody says Tories are mostly indifferent to the sufferings of the poor, maybe we say that's unfair to some conservatives and fair to others, but it's not necessarily likely to disparage the basic standing of Tories. So again, I think it's a matter of judgment. I think Jonathan's right. My instinct is always to think in terms of some continuum here where judgment has to be made. And yes, as in many other areas of legislation, we eventually look to the people we elect and hold accountable for the public good to make those judgments. Dangerous business. Not entirely clear how we would run a society if no such judgments were ever made in any area. Difficult judgments, even when they're controversial. Sorry, go ahead.
But the problem with that, sorry to interrupt, but is when you say, well, hold the politicians accountable, politicians are going to target unpopular speakers. So they will be popular. It's always popular to crush or stop unpopular people from speaking. So they're not going to be held accountable in the sense they'll be reelected because people love the fact that they're silencing people. And this insatiable appetite does go into political purposes. At GW, the students voted. It was a relatively close vote. 54% of the students at GW voted to get rid of our long-standing mascot, the Colonial. And the reason is because they felt that colonialism is a scourge, has racist, historical foundations, and they want it changed. I spoke against it by noting the obvious fact that the colonials we're talking about defeated the British Empire. They were against colonies. They're anti-colonials because they didn't want to be colonials. So you're getting rid of the symbol of anti-colonialism because you don't want to acknowledge the meaning and history of the term. And since we're an educational institution, that's troubling because we really think that matters.
And you convinced them, right?
Yes, thank you for noting that.
Maybe sort of go into the last question and then maybe perhaps give you each a chance, if you'd like, to sum up any argument. A number of the questions that I've gotten have really emphasized our changed technological environment and all this sort of the internet and, you know, the use of Facebook, which I'm not on, but Twitter, which I am on, but I do like to let people know I don't tweet after 2 a.m. in the morning as a matter of safety.
Sad.
And I'm very conservative about my use of caps, I want to add as well. But I kind of, you know, this really, I mean, it's really a couple questions. You know, one is, are we dealing really with a different problem than we've ever dealt with before? And are the things we're talking about really, in some sense, solutions for that different problem and not to the problem we're facing today, which is not so much the hate speech in physical forms in our campuses, and we can do with that what we want, but the truth is that it'll be spewed to millions of people, not to the hundreds who are perhaps here. And so, you know, what do you think we should be doing about that, if anything, and how does that affect our thinking looking into the future?
Yeah, I'll go first. I think it makes the problem immeasurably more difficult. And if one is concerned at all about the dangers of hate speech, it exacerbates the dangers, because people can now reach many others. You don't just have to go out and smear posters on lampposts. You post something on a website, particularly on the dark web, where you're connecting with, say, white supremacist groups, and you can have a disproportionate influence, and very, very quickly indeed. I think it is important to watch now how responsible governments, not necessarily what they're doing, but how they're thinking about this possibility. The Australian government is thinking about this a little bit in relation to the white supremacist influences on Brendan Tarrant, just trying to see how they're grappling with this. And I remain somebody who watches this with fascination and respect as I see good-hearted men and women trying to deal with this. Can I say just one other thing about this? I mean, there's a million things to say. So long as we're dealing with speech on the internet, we're dealing with a worldwide phenomenon. Unless we're prepared to put a firewall around the United States in its benighted acceptance of an absolute free speech principle. The fact is that hate speech originating in the United States is going to have an influence throughout the rest of the what we call the free world. And there's not much that can be done about that. It is a matter that ought to involve some degree of international cooperation. But if there are countries, and again I think of New Zealand and Australia, trying to think through that, the idea that we're going to sit on our hands and we're not going to do anything about this slaughter that took place in Christchurch on March the 15th. You know, we're not even going to think about it, because the beginning of thinking about it is the start of the long road to tyranny. If somebody says that, I have no respect for them. I do have respect, I think, for these people here this evening, because we've had a good discussion of the dangers of both sides. But I do believe those dangers are exacerbated and made immeasurably more difficult by social media.
Surprise! I disagree with Jeremy. On the internet, it is certainly the case that the European effort to restrict and monitor the internet is going to affect us. The fines being imposed on major companies have already unleashed all types of restrictions on speech that are already affecting the United States. It is not a good thing in my view. But this idea that we've got to do something about this is perhaps the siren's call we've heard since the beginning that free speech was recognized. The assumption that it's speech that's the issue. It's like that, remember that old story of a guy that was looking around in a dark road under a lamplight, and a guy came by and says, "Mister, what are you looking for?" He says, "A ring." And he gets down and he looks around and he says, "Mister, I don't think there's a wedding ring here. Are you sure you lost it?" He says, "No, I lost it down here, but the light's better here." Well, that's the problem with free speech, is that we all know, honestly, down deep, that it's not going to eradicate hate, to deprive people of free speech. It's not going to happen. Many of these massacres occurred in countries that prosecute people for hate speech. It didn't make them less hateful, but it did restrict the speech of everyone else. And so, yeah, it is true that you're going to have people that say hateful things. But for every of those occasions, on my blog, for example, I have a free speech blog, so I eliminate very few comments, so almost never. And occasionally people write me and say, "How could you let this comment stay there?" And I said, take a look what follows the comment. There's like 200 responses saying what a horrible human being you are, and I disagree with everything you said. Now, what was the outcome of that? Did we spread speech, or did we unify people against speech? And I think that's the problem with the European model.
So I don't know if either of you'd like a last.
You bet. I'm still hoping I can convince Jeremy. This could be a breakthrough. I consider this an intervention, right?
Well, I don't know if you will. I do want to add kind of one insight in the importance of dialogue and being engaged people. Maybe this surprised you. I've known Jeremy for a long time, and when we sort of had some communication, I said, "Who would you like to kind of engage with over this?" And he said, "Jonathan Turley." So I hope that's a reflection of the kind of engagement that we seek at this university. I want to thank the Boniuk Institute again for fostering this dialogue, which at least I've found interesting. And I would just thank all of you for coming to participate with us, and ask you all to thank once more Jeremy Waldron and Jonathan Turley for being here with us tonight.
Thank you.